Hello, everyone. Happy Friday. My name is Christina Jimenez, and today we have some very, very special guests. We have Miss Cruz, one of the paralegals at our office. We also have Miss Montoya, another paralegal at our office, and we have Mr. Floyd, the grumpy attorney. And so every Friday at noon, we come together and we do an event where we talk through complex legal patterns. So I've been doing this now for about 14 years. Mr. Floyd's been doing it for about 10, and Maria and Karina have been with us for quite some time. And so essentially what we do is we have fact patterns that we walk through. And we will kind of give our opinions on what we think the court might do and what we think the parties should be doing. I will say at the beginning, middle, and end of this event, please do not consider this as legal advice, okay? Our goal is to provide you a little bit of insight about what could potentially happen, but every case is different. And you'll see as we're talking through these things that the smallest little nuance in your fact pattern could change the trajectory of the entire case. And so it is so very important that if you find yourself in this situation, that you go and you hire an attorney, preferably in the county where you reside, or where the case is going to be, and you listen to that attorney. And maybe, hopefully, you can talk to them and say, well, hey, I heard, from this podcast or from this event that, this could potentially happen. And maybe it'll give you a little bit of insight and a little bit of clues. And hopefully it will give you a lot of hope when you're going through this process, okay? Do not accept that as I said, as legal advice. Make sure that you guys follow us on Facebook, YouTube, TikTok, Instagram, any social media platform that exists. Keon has us on that platform. It is also important, or we also have, a podcast on Spotify and Apple. So y'all can find us there as well if you want to listen to some of our old events. I'm getting feedback. Is anybody else getting the feedback? No? Okay, perfection. So with that being said, can someone read the first question while I get my life together over here?
Why is my divorce still pending? My wife divorced me and is now remarried. She got married on August 19, 2021. I found out our divorce is still pending. How do I fix this?
Want me to take it?
Yes.
Oh, I didn't know if you were asking the question to CJ or not. All right. Well, I don't know. There could be any number of reasons why you're divorced. Because it hasn't been finalized? Maybe?
Because they didn't hire the Jimenez firm?
Do what?
Because they didn't hire the Jimenez firm?
Possibly. Yeah. So if your divorce is still pending, she can't get remarried because she's still married. And in Texas, she can't be married twice. Your divorce is still pending. I don't know. I don't know what's going on. This is it could be because you're waiting on documents. It could be any number of reasons why your divorce is still pending. I suggest maybe you hire an attorney to figure out why your divorce is still pending. But in order to finalize it, you've got to go before the judge and you've got to get the divorce granted. You've got to get a final decree signed. So if those haven't been done, that needs to be done. But I don't know what the holdup is. That's all I have to offer. I don't know what on a question. It's open-ended, very broad question.
Then it says that the wife.
Go ahead.
That the wife it says my wife divorced me and is now remarried. So I guess he believes that he is divorced, but they're not divorced because they're still married because their divorce is still pending. But if the wife got remarried August 19th of 2021, then she is now married to two people.
What if he doesn't have a copy of the final order that's signed and he thinks it's still pending?
Oh, so now we're presuming that he's wrong and it's not still pending.
I don't know. I mean,
Christina goes down those paths. Let's do it.
It could be, has he gone to the court and asked the clerk for a copy of the final order? Has he researched it himself? I mean, is he just going off of something he has at home and it's not signed?
Yeah. If the divorce is still pending, you can't be remarried. I don't know. You need to hire an attorney and they can look up and figure out whether you're divorced or not. But if you're not still divorced, then you need to get a final decree entered to be divorced. And if you're not divorced, you can't be remarried.
So this is interesting. What happens if, hypothetically speaking, wife entered into this marriage, the second marriage, not knowing, or I guess maybe even knowing that her first divorce wasn't valid and or wasn't granted, and then she acquires a bunch of property while she's presumably married to the second husband, but she isn't, and that second marriage is technically void.
So you're saying she enters into a second marriage, she obtains a bunch of property, still married to guy number one. How does that affect the property, community property of her in the second marriage?
Or what is this guy entitled to in the first marriage?
Do you want my guess?
Sure. Guesses are good. Guesses are good. We accept all guesses.
So I think guy number two, husband two, although the marriage is void, would be able to claim putative spouse. That way he doesn't lose his interest in that property. Therefore, she would only have a 50% interest in the community property that was acquired during the second marriage, because under putative spouse, he could still get his portion. And so the community from the first marriage would own 50% of the property that was acquired during the second marriage. So husband one would have a 25% claim to the property that was acquired during the second marriage.
So that's what I was thinking.
Of course it was. Yeah, I should have known.
Of course it was. And so, I mean, would it be in his best interest to move forward with the divorce if it wasn't granted? First husband?
Okay. Okay.
First husband.
Yeah. No, it wouldn't.
I don't know. Maybe he'd be getting 25% of homegirl stuff that she's acquiring during the second marriage. And I think that it comes down to her knowledge maybe, and what she believed or why she believed the divorce was granted. Does that matter? I always get confused with the meretricious spouse and the putative spouse. Do you remember the two differences, Floyd? Let us Google. We're doing some legal work here.
Always start good legal research with Google.
Do you remember?
I don't.
I mean, I'm just like, this is obviously not something that comes up very often, but I think it would be something that I would want to explore. That a lawful marriage between them. So meretricious means that it's a marital-like relationship, but they both know that a lawful marriage does not exist. So yeah, I think it's just interesting. But like Floyd said, what you need to do is you need to talk to an attorney, and they can figure out very quickly if a final decree has been signed by a judge, which is what you need. And if it hasn't been signed, then I would want to kind of explore what could potentially happen to wife and how all of that would shake out. And it may not be something that he cares about, but
I don't remember. So there's something about the second marriage begins when the first marriage ends, right? I don't know if that goes to a mistaken belief that they weren't already married, or if it's done intentionally, like they knew they were married but still got remarried, whether that has an impact on the second marriage becoming valid.
So putative spouse, they did not have knowledge of an existing impediment to a valid marriage. And so I think it goes down to also the new husband's knowledge and whether or not he believed that the divorce had actually been granted. And I know that it would affect his property rights as well. And so, yeah, that would be interesting. I would want this case just to learn some more stuff. But
the second marriage is void, right? But like I said, there's something about it becoming valid after the first marriage ends. And I don't know under what circumstances it just becomes void altogether, and under what circumstances it will pick up after the first marriage ends. See what I'm saying?
Okay, interesting fact pattern. How do I fix this? If your divorce is still pending, like, get divorced. That's how you fix it.
Or does he not want to get divorced?
Or maybe we don't want. Okay, next question I will read. So actually, Maria, Karina, why don't you read this one? Sorry.
The denial of paternity have to be signed if one does service by publication and the spouse was in default for divorce. The biological father is willing to sign the acknowledgement of paternity, but it states that if one was married during the time of a child's birth, the spouse has to sign a denial of paternity. This cannot be done if he cannot be found and there is a service by publication done for divorce. It is a known fact that the spouse is not the father. We have been separated since 2007. I have not seen or heard from him in over 2 years. Would this still allow for the biological father to sign and the divorce to be finalized without a denial of paternity?
This you, CJ.
So you can't do the denial of paternity because the denial of paternity is going to have to be signed by the presumed father. And so assuming that the divorce and what we would have done, so would this still be for the biological father to sign and the divorce to be finalized? So typically what we would do in this type of case is we would file a petition for divorce, and within the petition for divorce request an adjudication of parentage. And Floyd, correct me if I'm wrong, but there's two ways to get a presumed father kicked off the birth certificate or to find that he's not the actual legal father. The first is the denial of paternity signed in conjunction with an acknowledgement of paternity, which basically says the bio dad signs saying, hey, I'm legally the father. And then the presumed father signs and says, hey, this isn't my kid. And then you file that with the state case registry, Karina? Is that, or the vital statistics?
Vital statistics.
Okay, so you file that with the vital statistics, and then that's sufficient to make the acknowledged father the potential or the actual legal father. Okay, now the second way to do it is with a genetic test. And so you can request that bio dad take a genetic test, that screen comes back, he's the biological father, and then the court would make a finding that presumed dad or the husband is not the actual legal father. Floyd?
Yeah.
I nailed it, right? Nailed it.
Yeah, so in the decree, they would do an adjudication or a non-adjudication of parentage.
So non-adjudication of presumed dad, and there would be findings of the fact that bio dad is real dad. And
But
then
that doesn't make him an adjudicated father.
Well, and that's what I was going to say. So if bio dad wanted to establish his rights to the child as an adjudicated father and set up like conservatorship rights to make decisions and visitation and all that other good stuff, he would have to intervene into that divorce and then request that all of that stuff be set up in its own order to adjudicate parentage for bio dad.
Yeah, and even if your wife didn't request genetic testing in a divorce, he could intervene and request genetic testing and be adjudicated father under that.
Correct. Correctamundo. Okay, so next, I will read. If my final hearing ended up not resulting in a final divorce and I don't agree with the orders, what can I do? I don't agree with the orders and I would like to add my input and request for things to be changed. What can I do? How do you have a final hearing and it not result in a final divorce? Judge, just render temporary stuff and reset the final?
Reset the final, revisit a proposal.
Yeah, that's the only way. It'd have to be a temporary order, because if it's a final order, then it's a divorce.
Okay, so Maria, what say you?
Reset the final hearing.
Well, but if the court rendered temporary orders, because obviously they put something in there and she wants or he wants it to be changed, then what happens?
So are we modifying temporary orders? So then we would go back and, or would file a modification of temporary orders and just address what we are wanting to change.
Correct. And I guess it kind of depends on what the judge ordered and why the judge ordered it and what happened since rendition of that previous order. So this is always the thing that really pisses a lot of clients off, is like, let's say hypothetically, they come in and they hire us after they already went to a temporary hearing. And at that initial temporary hearing, things just go south for them and they get a really bad ruling. And so they want to come into us and say, hey, we need you, or I want to go back to court and I want to fix what happened at this temporary hearing. And that temporary hearing just happened like a couple weeks ago. You don't get a second bite at the apple when that happens. Okay, so you don't basically get to go in and say, well, my first attorney screwed this thing up, or I didn't have an attorney and I couldn't present my evidence, or the way that the evidence was presented, it wasn't the correct way. And so now I'm ticked that the judge ordered the way that he or she did, right? Typically, if you're going to modify something, it's going to be based on something that happened after that ruling, right? And typically we will not go back. I mean, if there's nothing that's different, then we're not going to go back, because most judges will be pretty upset that you're trying to retry a case, just because, you know, things went south that first go around. So typically what we would do is we would talk to this person and say, all right, well, what's different? And why do you think that things should have been changed? And then you go in and you present different evidence if things have changed. And if not, then you kind of just have to ride it out until things change. Floyd?
Yeah, most of the time, right? We've done motions to reconsider, right?
Didn't we figure out like that wasn't an actual thing?
It's not an actual thing, but we've done it. Sometimes we make shit up to get what we want, but yeah, so I don't know why she said she would like to add her input, right? I don't know if she didn't get to testify or if she thinks that she has a say in what the judge orders, maybe, but she doesn't. It's not like a negotiation when the judge is rendering an order. It's just the order. You don't get to say, but what if we did this? You can't do that. So
Right.
that's what you mean by add your input. You're wasting your time.
Right. And I mean, typically in a case like this, what we would do is we would get the transcript, right? So we want to see what actually happened. What did the judge order? Was it in fact temporary? Was it a final? Like what happened? And then from there, after we review the transcript, and some of these transcripts, guys, I mean, depending on the length of the hearing can be several hundred pages. And so we go through and we read all of that. And then at the end, we say, okay, well, there's some potential hope here. And this is how we think, this thing might shake out. Or you're screwed and there's really not anything we're going to be able to do because whatever happened at the hearing happened, right? And so without that transcript, we really can't make a plan. It's kind of like when you go to the doctor and they know something's wrong with you and they have to run all these tests on you, and then they get the reports back and they say, all right, this is how we're going to proceed. Same thing in the legal profession. We have to look at all pleadings. We have to look at the transcript. And then from there, we get to make a determination on, all right, here's how we're going to try to get you out of this situation. But for all we know, it could have actually been a final rendition of an order. And then if that were to happen, you'd have to wait till the entry of the final decree. Then you'd have to potentially move forward with a motion for new trial or a motion to set aside default judgment if she wasn't actually there. And this thing could go all over the place. Like there's a lot of potential problems and maybe even some saving grace, depending on what happened. So, cool tool. Who's reading next?
I'll read. Okay, so help me understand parental rights and responsibilities versus conservator rights and responsibilities.
Not it.
We're reading on.
I wanted to give Pre-Nut questions. She hasn't got to answer one.
So, as far as conservator rights, I mean, they're very similar to parental rights, right? I mean, it's really just rights and duties, what you are allowed to do as far as the children are concerned, make decisions regarding moral and religious training, taking them to the doctor, taking them to have procedures done if they need it, attending school activities, they're very similar. But I guess there's a list, pursuant to the family code, that is included in most temporary orders and final orders that are related to children. And then the parental rights, I mean, I guess that's just kind of, the sky's the limit. Whatever you want, whatever right, really, as long as you have, your children in your possession, right?
So I don't know, like, honestly, I don't know what the difference is. Is there a difference?
I would just say that, I mean, I think they're intended to be the same. I think you have parental rights, which are just rights that everybody knows you have as a parent. And then the legislatures took those, codified them, and called them conservatorship rights, and intended to include all of the rights you had as a parent as a conservatorship right. That's, I think they're the same. I just think that they wanted to be difficult and call it conservatorship rights.
But is there anything in the family code that says like parental rights? These are your rights as a parent?
I don't know that I've ever read that.
Like, I mean, for me, like, I'm not divorced. I don't have an order. So, like, how do I know what my parental rights are? I'm so confused by this question.
The sky's the limit.
There you go.
Whatever you want to do. It's your, it's your right as a parent.
I mean, I would presume, like you're saying, it's the exact same thing. I've just never like taken the time to think about it. But obviously I can make all those decisions, medical decisions, etc., for my kiddos. Just haven't ever thought about it. So I guess, so let's talk about like the information rights, which is kind of the right of a parent to get information from third parties and from the other, right? Everybody, whether you're a joint managing conservator or a sole managing conservator, typically has the rights to get that information. And Floyd, isn't there like an affirmative finding that the court can make to prevent someone from getting the information?
Yes, they have to remove them as a conservator completely, right? And I think it's that it would place the child in danger or whatever, or something like that.
Right. So those are typically, that's reserved for really, really bad situations. And I think I've only ever had that happen in one case, and it was a really bad situation. And so typically both parents are going to have the rights to get information about the kiddo from the other parent and from third parties. Then you have your decision-making rights, which is kind of what Karina was talking about, which is the right to make invasive medical decisions and the right to make educational decisions, psychiatric and psychological decisions, the right to designate the residence, to get child support, so on and so forth. And if you're drafting an order and you're doing conservatorship rights, y'all can divvy that up any way you want to. You can make them independent, which means either parent can make the decisions for those decisions for the kiddo. You can make them subject to agreement, which means both of you guys have to agree, or else it's not going to happen. You can also do a tiebreaker if you're doing that. You can say, well, I'm going to give invasive medical to mom and I'm going to give educational to dad. Like, there's really just a myriad of things that you guys can do when it comes to these conservatorship rights. And a lot of times in mediation, that's one of the things that we kind of bargain with, right? Well, she really wants to have the right to make educational decisions. And so let's take the psychiatric decisions. So definitely something that you need to think about. Floyd, what do you think is the most like problematic right, other than obviously the exclusive right to designate the residence?
The one that we have, like, they fight over the most?
Yes.
Educational? I'm in the air between education and medical. But a lot of people misunderstand the medical one, right? So I'm going to go with educational. Okay, well, I guess I'll just keep talking.
Agreed. No, I agree. I agree, because I think typically when people are still together, they typically have the same, idea as far as education for their children. And then once they split up, sometimes, one could go a different way. And so they want their children to follow what they're, what they want them to do, I guess. And the other party might not agree. And so I definitely think I agree with you.
Well, so now, and this is recent, they have, so you have the right to make educational decisions, but now the legislature added in that one parent, and it's typically the parent that the children reside with, have the exclusive right to enroll the child in school, right? And so that is also a right that presumptively at mediation or even at a contested final trial, you could say, look, I know that kiddo's going to be living with that parent, but I want to enroll my child in this private school. So I want to have the exclusive right to enroll. And then there's also an affirmative order that says that each parent is ordered to make sure that we get the kiddo to school in the school that they're enrolled in. But other than where the kiddo goes to school, what other educational arguments are there? If they should be held back, if there's
public, homeschool or not. That's homeschool.
But typically when we know that that's going to be an issue, we're litigating that stuff. I don't see that really, I guess it could come up after an order is rendered when they get remarried and stuff.
I've got one like that now.
Yeah. Yeah. The one I was going to say is the psychological and psychiatric one. I don't think that's like a big deal. Like the
one of the least ones that was litigated.
That's always a right that I want to, depending on the age of the kiddos, that's a right that if I can have it, I want the exclusive right. And especially if there's any sort of parental alienation on the other side, or if there's any sort of like just mental health concerns that you have for your kiddo because of the way that the other parent is behaving, if there's any concerns of emotional abuse or things like that, what you don't want is, for sure, you don't want a joint agreement situation, right? Because if that other parent is in fact doing some sort of bad acts to the kiddo, you're not going to be able to get the kiddo in counseling or to get any sort of psychiatric or psychological help for the kiddo because the other parent is not going to let you do that, right? And then I would want to advocate, if I had those concerns, to have those exclusive rights so that I could make sure that I could get the kiddo the mental health that they need so that we don't have any impediments. What are you making faces at me for?
Well, because you have that right with an independent right, and I don't know why in the world any attorney would give up that right. Because if then the other parent is doing something wrong, they can't get help for the child, right?
So the problem that you have, especially when it comes to counseling and even like the psychiatric and psychological care, is a lot of these counselors, if you don't have both parents agree to allow that kiddo to go to that counselor, they won't see the child. And so even if both parents have these independent rights, then you're still in this situation where you're not gonna be able to get the kiddo help because the other parent won't agree. And so, and maybe it's not something that the other parent will give up, but it is something that we've litigated before. And typically what will happen is the judge will say, okay, I'm going to give, dad the exclusive psychiatric and psychological, but I'm going to give mom the exclusive medical, right? Or, I'm going to say, joint agreement. If you guys can't agree, then the pediatrician makes the call, things like that. But
Or a counselor.
Or they'll designate a counselor and then the kiddo goes as designated by the counselor. I don't know. I just feel like that's I'm all about mental health, like big into mental health. So I feel like that's something that is very important. And I feel like most kiddos that go through a divorce should probably shut up, Floyd.
I didn't say anything.
You don't have to. Your face says everything, that they should probably get some counseling. I think it's good for them. Right, Floyd? Or you can read a book. Or you can watch this podcast or live event, whatever the heck it's called. But I just think that it is important, and mostly it's important when they get a little bit older, because that's when the issues really start to kind of creep up, depending on the parents, which is why we always encourage all parents to not put their kiddos in the middle, because this crap's already hard enough. So anyway, next question. Yeah. Okay, let's do this. Maria, I'm going to question 9. Is it legal to change pickup and drop off locations when a court order is in play? My ex-wife wants me to start picking up my kids in a different city from where I've been picking them up from divorce decree. The decree says that we're supposed to exchange at a party's residence.
So even though there is an order in place, it still allows for mutual agreements. So if they're both in agreement to have the children's being picked up in a different city or whatever other issues, but they both agree, they can still switch the city. But if not, if they both don't agree, then they need to look at the order and see what is in place.
Okay, so follow the order unless there's mutual agreement. But what if mom moved to a different city? And the order says you exchange at their residence. And you pick up at the other city, right? Where mom's living?
Yeah.
Yes. The answer is yes, Maria. If that's what the order says, and assuming that mom is permitted to move, then that's where you go. Yeah.
Yeah.
Okay.
So the problem with this, though, is if you agree on a different location and someone doesn't get visitation, someone doesn't show up, like, can you hold them in contempt?
No.
So that's the issue. So if you start having problems of people not showing up on time or not showing up, then you just have to go back to the order and start exchanging at the residence.
Well, and then here's the other thing, guys, that people, now I'll say that it's typically moms. Moms will say, this is where you have to pick up the kids if you want to see them. And it's not an agreement type situation. It is either you do this or you don't get to see your kids type situation. And so when we say mutual agreement, or when the orders say mutual agreement, that means it has to be mutual. That means you both have to agree. And if dad says, no, I want to stick with the order, you don't just get to say, F that, we're not doing that. Because that's how you end up finding yourself in contempt of court, because you're not following the order. So where it becomes tricky is if, and this happens quite a bit, is like the parties come to an agreement for a visitation period or for a exchange location, and then at the last minute, one party rescinds for one reason or another.
Yeah, that sucks. That's rude.
So rude. But
You're stuck like Chuck. You still have to follow the order.
you do.
And it's real shitty when they do it. They like switch weekends, right? And they get their weekend. They're like, never mind. Don't give me
Never make them up.
Well, and I've had that happen where, like a parent has decided, like a mom said, okay, well, I'm going to give you this Thanksgiving as long as I can have your Thanksgiving next year. And so then mom does that. And then the next Thanksgiving comes around and dad's like, psych, you can't have them. And they call us in tears. And I'm like, I'm sorry. What's good for the goose is good for the gander, though. That's all I can say. And so y'all start playing those games. Don't be mad when it happens to you. So don't do it. How about that?
Because you're really putting the child in the middle then, right? I mean, you're punishing the other parent by possession with the child, and that's rude.
Right. So, but what I would say, going back to what Floyd says, is if y'all come to this mutual agreement thing and then one party rescinds, I don't know. Well, I would say typically a judge isn't going to hold you in contempt for doing that. But I would say that if the other party filed a motion with the court and said, look, judge, we had this agreement, I planned all this stuff, and now they're backing out of the agreement, that a judge could basically say, hey, I'm going to let them have this kid over this period of possession. I'm going to order it now because you're inconveniencing the other side. And I think in that case, a court could potentially assess attorney's fees and all sorts of things. And so don't do that. If you have a legitimate reason as to why you have to rescind, the court's going to take that into consideration. But if it's just because you want to be an ass about something, it's probably not going to go well for you. And so I don't know that I've ever had it happen in a case, but if that happened to my client, I would probably ask for any non-refundable fees, any, time off, like any travel expenses, like all of that stuff. I would ask for it just to kind of punish the other side for doing that. So don't do that. It's not nice. What else? So rude. Anything else on this?
No.
Okay. Next question. Shall I read?
I have lost track.
Okay, yeah, I've been marking stuff off because we're bouncing all over the place. Maria, why don't you read number 6 for Mr. Floyd?
How can I obtain a divorce
Wait, whose cousin is Yvonne Pantoja? That's Maria's cousin.
That's certainly not my cousin.
Say hello to your cousin, Maria.
Hi.
Okay, go ahead.
I'm embarrassed.
Wait, was she talking about somebody that's on here or somebody that asked the question?
Somebody on here, that's Maria's cousin, Yvonne.
Oh, how do you know that?
I literally just asked Maria, where were you?
Oh, I thought you said, Maria, that's your cousin. Okay, go ahead.
Okay.
Go
How
ahead.
can you obtain a divorce from an uncooperative husband living out of state? I filed for divorce 3 years ago, and my husband is not cooperating or responding to the mail sent by the judge, and he stays mostly out of the country in Africa and even got married. What do I do?
This is another guy that got married while he was still married.
If it didn't work out the first time, why are you guys getting married?
Well, maybe he got married in Africa. How does an African marriage affect a marriage in the US?
It's still the same.
No marriage.
So the African marriage is void based on Texas law?
Texas.
I don't know.
I don't know.
Well, what if you can have more than one wife wherever they're living? What if that's legal?
That's what I'm saying.
Yeah, I don't know. But that's not the question.
I know.
We
but
digress.
it was fun. Okay, so what you do is you set a final hearing and you send them notice to the last known address, the address that he has on file.
What are you talking? How'd you establish service, sir?
Filed for divorce. He's not cooperating or responding to the mail. So I
Mail sent by the judge.
Yeah, the judge doesn't send service, so I assume that he was already served, and now judge is sending notices of something or other. But if he hasn't been served, we want to go, he hasn't been served? Okay, so he hasn't been served based on Christina's fact pattern.
Wait, can you explain to me what service is, Mr. Floyd, and why it's important in all cases?
We're gonna take this question all the way down. Okay. So, service is notification that a suit has been filed against you. After you have been served, you have until 9 a.m. on the Monday following the expiration of 20 days to file an
Look
answer.
at Karina. Karina's like,
10 a.m.
wrong.
10 a.m.
We need to have a little buzz.
Exactly.
I need a drink.
Wrong.
I need a drink. 10 a.m. on the Monday following the expiration of 20 days to file an answer. If you don't file an answer, you can be defaulted. Now I'll go in and explain what a default is. So a default is
Right. Well, sir, what if we can't ascertain service because he's in Africa most of the time?
I haven't finished explaining all of this yet. I'll get there, man.
You said you were moving on from service.
Will someone tell her what I said?
They don't know because you didn't say it.
I said, now I'm moving on. I'll explain what a default is.
Okay, go ahead, Mr. Floyd.
So a default is when you go to court because nobody responded and you can basically get whatever you wanted. I
I'm
was
gonna object as to non-responsive to my question then.
yeah, so service is given them notice. Most of the time it's done via personal service. You have a process server go out, hand them the documents and all of that jazz, gives them instructions on how to file an answer, kind of tells them that they have to file an answer rather. And so if you can't obtain personal service because the guy's married in Africa or whatever's going on there, then you can do some type of alternate service or potentially service by publication. So alternate service allows you to serve him by any means that the court believes would give him notice, right? Would be sufficient to give him notice. So we've done service via like messenger apps, Facebook, text message, emails, mailing to last known address.
Serving third parties, family members, serving your place of employment.
Yeah, it's really unlimited as long as you can establish to the court that this means we'll give him notice, right? So yeah, you got to do that. And if you have absolutely no idea where he is and no way to contact him, then you'd have to do service by publication, which used to mean you had to publish the citation in a newspaper, but it no longer means that in the state of Texas. Now you can post it on a website, and then once service is done, then you can set a final hearing. And if he doesn't show up at the final hearing, you can ask the judge to go ahead and grant your divorce. Is that everything? Or do you want So the final hearing, you have to give at least 45 days notice, right? So you
Uh-huh.
set it out far enough.
Wait, if he doesn't respond, you have to do that? Yeah. Golly, Floyd.
You don't have to give him notice.
Who said he didn't respond?
I just did in my
talking about a default.
hypothetical.
All right, so facts pursuant to Christina, this guy didn't respond. So then you would set a default hearing with the court. And most courts, you don't have to give notice of that. Some of them you do.
Some of them you do, yeah.
Yeah.
Sure.
So then you would just show up at the default hearing and announce that you show proof of service, he failed to file an answer, and you get whatever it is that you pled for. Now, assuming that he did file an answer, then you would have to set a final hearing, send notice of the final hearing, and then same thing if he doesn't show up at a final hearing.
So here is what I will say. If you are someone and you find yourself in this situation where you can't get the other party served or they're being uncooperative or whatever.
Hire an attorney in your area.
Yes, absolutely. Because the thing is when it comes to these motions for alternate service or citation by publication, it's very hyper technical. Okay. And if you do not comply with the codes exactly as they're written, what you could do is you could issue, service, and then you could go and you could presumptively maybe get a default judgment where you get everything that was acquired during the marriage. Maybe you get the children and child support and spousal support and you get all this beautiful stuff. But then a few years later, you get served with a bill of review because service was not effected properly.
Wait, what's a bill of review?
So a bill of review is a motion that you can file. Mr. Stewart feels bad for you, Mr. Floyd, by the way, because you're getting beat up by not only one, but 3 women.
Thank you, Mr. Stewart. This is my life every day at the firm.
A bill of review is so let me back up.
Question.
I am. It's a complicated question, Floyd. So when a final decree or a final order is rendered, typically you have 30 days from the date that the judge signs that order to come back in and to say, hey, judge, something screwed up on this thing. I need you to set this thing aside and let me actually show up and present different evidence or more evidence or some evidence, whatever. And so the judge can have a hearing and say, yep, I'm going to reopen the case. I'm going to set that final order aside and I'm going to let you present your case. Or he can say, no, you already had your shot. You screwed it up and the order's staying as is. Okay. So typically that's the best way to get rid of an order. But if for whatever reason you didn't know that the order was granted, potentially because you were in Africa with your new wife and you didn't know that you had been legally served or illegally served rather, because maybe the attorney that your wife had hired screwed it up, then you can come back years later and file what we call a bill of review. And basically what you can say is look, judge, service was not affected properly. And since it wasn't affected properly, since I didn't know that this had happened because they screwed up on the motion or the publication or whatever, I want that decree to be set aside and I want to reopen everything. And there's some really good case law out there that would support that contention that it should be reopened. And so, which I will say that I did all the research and I found all of those cases on that issue, right, Floyd?
Absolutely correct, yes.
And so that Floyd found for me and showed me. And so that would be a problem, which is why you have to make sure on this type of craft that you just come up with the money, you hire somebody that knows what they're doing and get it done right, because that could have devastating consequences in 4 or 5 years or whatever it is.
So 2 things. First is on the bill of review, like Christina said, it opens the case back up. So if you're looking at doing this a few years down the road or a few years after it was granted, that's something that you got to consider, because if you open it back up, now everything you've acquired since the divorce is now community property, subject to division, and it could cost you a lot more money than what the divorce just initially cost you. And then second thing is, on the alternate service, to get alternate service, you have to submit an affidavit. Don't lie on the affidavit. If you lie on the affidavit and get alternate service granted based on that, it's going to be overturned.
Yeah, like I don't know where this person lives, and yet you sent them a letter like 2 weeks before you signed the affidavit.
Yeah, let's move on past this.
Okay, very good. I feel like this may be a problem.
Very
for
tough
someone.
situation for you.
Okay, very good. So, yeah, good. And that's actually solid advice all the way around, is don't lie on affidavits. Yeah, probably not a good idea. So,
Or change them or anything like that after they've been signed, right? You just.
right. Right. Yeah. So, anyway, any other questions or concerns on this issue? Did we thoroughly cover it?
I think just on the citation by publication, maybe you guys mentioned it and I missed it, but we didn't mention ad litems, but that is also something that's usually required on citation by publication.
Do tell CM.
Well, it's required whenever you post it, then you have to, typically the person who filed for divorce or who filed the suit has to incur that cost of hiring another attorney to represent the interest of the respondent, who they're trying to serve by publication. And so then they end up paying that attorney ad litem. That attorney is responsible for looking for the respondent and, you know, trying to see if there's any indication that that person can be found. And if they can, then they, you know, of course, file a response and make sure that they're involved in the case. Or if they can't, then they just provide that information to the court to explain, you know, what they did to try to find them and that they were unsuccessful, and then they're able to move forward that way as well.
So one slight correction, Karina, if
Yes, ma'am.
the ad litem finds them, then that discharges their duty, right? Like they basically come in and they say, hey, judge, I found John Smith and I sent him a copy of the decree the petition. And then at that point, typically the court will say, okay, I'm going to discharge you from your duties. And then it's going to be on husband to hire a lawyer. Maybe he hires the ad litem or whatever, but to hire a lawyer. But their sole role when they're appointed by like after a citation by publication is just to make an affirmation to the court or report to the court, like, yes, I found him, or no, I didn't find him, right?
Gotcha.
After a diligent search. Floyd and his faces. Tell me, Floyd, where did I screw on that?
I don't know that I've had a case where an ad litem actually found the other person, but you had said something like they find them, they send them the documents. Is that service? Or how do you get them served after the ad litem finds them?
I think in a case that I remember, the attorney did file responsive pleadings for the respondent. I think that's why I was thinking maybe was that incorrect? I don't know. Should they would have done that? Maybe they were hired. I don't know.
No.
You did.
Okay, they were not hired.
But if their obligation and their representation of this person ends once they're found, right, and they don't file responsive pleadings, how do you serve them?
So I don't know, actually, because so the one case that we had this, like you said, Karina, the ad litem had filed an answer, but the ad litem should not have done that because there was a potential jurisdiction issue, and that was that the other side could have alleged on personal jurisdiction, and so that prevented that party from making that assertion. And so I don't know as an ad litem if you should file an answer when you don't know where this person is, because what if they've never resided in Texas and Texas doesn't have jurisdiction? Now you're waiving those arguments. Okay. And so Floyd, I would presume that as the ad litem, Where's Julie? I wish Julie were here. As the ad litem, you do notify them, like say, well, here's your pleadings or here's what's going on, and they make that representation to the court. And if at that point you have an ad litem making that representation, and the service was done by citation by publication, silly. And so if they find them and then they make a report like, hey, I find him and I told him, and then at that point they don't file an answer, then that's on them. And we get to proceed with the default.
Yeah, so.
Yeah. So, okay. Well, I believe that we have 3 minutes. Can we answer anything in 3 minutes? Can I answer anything?
Not do anything in 3 minutes.
Well, maybe I don't talk. Maybe I'll ask the question. Are temporary orders in pretrial really temporary? I feel like I have been bamboozled in a temporary visitation case. I love that word. I signed a temporary order, but somehow I feel like the temporary order is going to become permanent without my permission. Are temporary orders just what they say they are, or was I fooled? Was I bamboozled?
You, sir, were bamboozled. Yeah, so for the most part, temporary order sets the stage for final, right? And so we focus a lot of time and effort on the temporary orders and the contested temporary hearing because it does set the stage for final. And absent something changing between temporary and final, that's going to be what the court uses for a guide. So bamboozled you were.
Yeah. I always say that I think temporary orders are just as important, if not more important than a final, because if you can win that, it's going to be hard for somebody to take it away from you. So don't just write those off like, oh, it's just temporary. That's a big deal. Very big deal. So with that being said, go ahead.
Did it in under 3 minutes.
With that being said, Maria and Karina, thank you guys for joining us today. You all are absolutely amazing. And here is our lovely disclaimer. So as I said in the beginning, I don't know that I said it in the middle, but I will say it now. This is not legal advice, so do not accept it as such. This is basically our thoughts that we have with regard to these particular fact patterns. If you find yourself in this situation, please hire a good family law attorney in the area where your case is being litigated and follow their advice and tell them your story so that hopefully they can guide you in the right direction. And with that, I think we are done. Y'all have a good Friday.
Alrighty, doodles.
Bye.